A federal judge has just blocked enforcement of a gun law, and almost immediately the headlines exploded. Some are calling this a major victory for gun owners. Others are saying it won't last, that it will be overturned, or that it doesn't really change anything. So today we're stepping back from the noise and answering the most important question. When a federal judge blocks a gun law, what actually happens next? What does this ruling mean right now? Is the law gone or just paused? Can the government still enforce it? And what almost always follows after a judge issues one of these orders? Because if you follow gun law cases long enough, you start to notice a pattern. And understanding that pattern matters far more than reacting to a single headline. When a judge blocks a gun law, that phrase can mean a few different things. In most cases, it refers to the court issuing an injunction. There are three main types you'll hear about: a temporary restraining order, often called a TRO, a preliminary injunction, and much less commonly, a permanent injunction. In gun cases, the most common by far is a preliminary injunction. A preliminary injunction means the judge has reviewed the early evidence and arguments and decided that enforcing the law right now is not appropriate while the case continues. To issue that injunction, the court must find several things. First, that the challengers are likely to succeed on the merits of their case. Second, that enforcing the law would cause irreparable harm. Third, that the balance of equities favors stopping enforcement. And fourth, that doing so is in the public interest. This is not a final ruling on constitutionality, but it is a strong signal. The judge is essentially saying, based on what I've seen so far, this law may not survive, and enforcing it now would cause harm. So does the law immediately stop applying? Usually, yes, but with important limitations. Once the injunction takes effect, the government is generally prohibited from enforcing the law against the parties covered by the order. That means no arrests under that statute, no prosecutions based on it, no penalties or enforcement actions tied to it. Agencies are required to stand down, at least temporarily. However, not all injunctions are created equal. Some are nationwide, some apply statewide, and others apply only to the specific plaintiffs who brought the lawsuit. That scope matters a great deal. In some cases, one group of people may be protected by the injunction while others are not. In other cases, enforcement may stop in one state but continue elsewhere. This is one of the reasons confusion spreads so quickly after these rulings. The words blocked or struck down get used interchangeably, even though they mean very different things. And that leads us to a critical point. A blocked law is not the same thing as a law being struck down. At this stage, the law still exists. It is still written into statute. The legislature has not repealed it, and the court has not issued a final ruling declaring it unconstitutional. The law is frozen, not erased. Think of it like pressing pause, not delete. Courts are very deliberate about this distinction, even if headlines are not. So what does the government do next? In almost every gun law case where enforcement is blocked, the government has several immediate options. The most common is an appeal. The state or federal government will file an emergency appeal with the appellate court. They will often ask that court to issue a stay, which would put the law back into effect while the appeal proceeds. If the appellate court grants that stay, enforcement resumes. If it denies the stay, the injunction remains in place. Sometimes this happens quickly. Sometimes it takes weeks. But an appeal is almost always filed. Another option is narrowed enforcement. Rather than immediately escalating the case, agencies may quietly adjust how the law is applied. You may see fewer prosecutions. Guidance documents may change. Rulemaking may be delayed or paused. This does not mean the government is conceding defeat. It is often a strategic decision. The third option is legislative revision. This has become more common since the Supreme Court's decision in Bruin. Instead of defending the law as written, legislatures may amend it. They may add exceptions. They may reframe the statute to better fit within the legal framework courts are now applying. We've seen this happen repeatedly after early injunctions in gun cases. Now let's talk about timing and how long does a blocked gun law stay blocked? The honest answer is longer than most people expect. Gun litigation moves slowly. Once an injunction is issued, the case continues through briefing, discovery, and argument. That process alone can take months. After that, the district court will issue a final ruling, and almost always that ruling is appealed. In many cases, a law can remain unenforced for a year or more while the legal process plays out. That's why some gun laws technically exist but are not actively enforced. They're caught in legal limbo. A major reason these cases look the way they do today is the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin. Bruin changed the legal framework courts must use when evaluating gun laws. Under Bruin, courts must first ask whether the conduct being regulated is protected by the Second Amendment. If it is, the burden shifts to the government. The government must then show that the law is consistent with the nation's historical tradition of firearm regulation. That means pointing to historical analogs from the founding era or early American history. If the government cannot do that, the law is constitutionally suspect. This is why modern gun cases focus so heavily on history. Judges are examining statutes from the 1700s and 1800s. They're comparing modern regulations to historical practices. And it's also why many newer gun laws are struggling in court. Some people ask whether the Supreme Court can step in immediately. The answer is yes, but it usually doesn't. The Supreme Court has the authority to lift injunctions or reinstate laws, but the court generally prefers to let cases work their way through the lower courts first. It often waits for a full appellate ruling, or for multiple courts to disagree, creating what's known as a circuit split. Only then does the court typically intervene. That means most of these battles are decided, at least initially, at the district and appellate court levels. So what does all of this mean for gun owners right now? It means cautious relief, not certainty. A blocked law reduces immediate legal risk, but it does not eliminate uncertainty. Injunctions can be stayed. Appeals can reverse outcomes. Enforcement rules can change quickly. This is why responsible coverage avoids telling people to drastically change behavior based on a single ruling without understanding its scope and durability. Understanding what an injunction does and what it does not do is critical. And finally, it's important to understand why these early rulings matter, even if they are later overturned. Injunctions shape the entire case. They reveal how judges are interpreting Bruin. They force governments to show their legal arguments early. They influence how appellate courts view the dispute, and they guide how other courts handle similar laws. Even when an injunction doesn't last forever, it often sets the tone for everything that follows. So when you hear that a federal judge has blocked a gun law, remember this. The law is paused, not erased. Enforcement usually stops, but not always everywhere. Appeals are almost guaranteed, and the case is far from over. This is how gun law battles are fought today. Not in one dramatic moment, but through layers of courts, over time. And as always, the most important part of the story isn't just what happened today, it's what happens next.